on the iPhone.
Correct.
You had mentioned on direct that you had observed on the camera footage the suspect, Mr. Barber, tapping the guy with the red cap on the shoulder, right? And you had, well, just for the record, could you say yes or no?
I don't know if it was a tap on the shoulder. They at one point they were talking, and I believe that's when he told the individual with the red hat, like, "Hey, that dude has my cell phone."
Okay. However, you still said
I don't know exactly what he said, but based on Mr. Borghe's statement, when the individual tapped him on the shoulder, he turned and he told him, "Hey, do you have his cell phone?" And based on the footage, that's the only time the suspect communicated with that individual, which only leads to say that that's what he told him, since he immediately turned and tapped Mr. Borghe on the shoulder and says, "Hey, you have his cell phone."
okay. When you spoke, I'm jumping around a lot, I apologize. When you spoke with Mr. Barber at arrest, you mentioned that he made statements to you, is that right?
That is right.
Was there anything, I guess, abnormal about Mr. Barber's speech?
There was.
How would you describe his speech?
It was difficult for me to understand him at first. So he would write stuff down, but after speaking to him for a little bit, I kind of sort of got how he would say stuff. So I got his pattern. He would make statements in like 3 or 5 words, and he would then try to write something down, and he would continue to make statements.
All right, so it's beyond having like an issue with like a foreign accent or anything like that, right?
Oh yeah, it wasn't a foreign accent.
Right.
Yeah,
More so along the lines of a speech impediment.
I would say so.
Still though, you were able to understand what he was trying to communicate.
Correct. And that's also on video footage if you want to view it.
Right, your body cam footage, right?
Correct.
Was the iPhone 13 from Mr. Borgheat ever recovered anywhere?
No, sir.
All right, thank you, officer. That's all I have.
Redirect.
Yes, just one question. You mentioned to Mr. Rhodes that sorry for talking while I was walking up, that Mr. Barber had several cell phones on him. Do you remember how many?
I believe it was 4 cell phones. I'd have to check his property report.
Okay. Did you ask him, did those belong to him?
I believe I did.
And what did he say?
He said yes.
Did he indicate why he needed 4 cell phones?
I don't think he did. No.
Okay. Nothing further, Your Honor.
Anything else, Mr. Rhodes?
No, Judge.
All right. Anything else for this officer?
Nothing from the state.
All right. Stay safe out there. All right. Go ahead with argument.
Yes, Judge. I may be mistaken, but I'm not sure I heard venue be established here. We'd ask for this case to be dismissed for lack of certification of where this actually occurred within Fulton County. But also we would ask for the robbery charge to be dismissed on the merits under probable cause. The iPhone that was allegedly taken was never recovered, and there may be an identification issue. I'm not sure that Mr. Borgheat himself ever identified personally the perpetrator or assailant who may have robbed him. From what I understand, the complaining witness, yes, made a statement, reported something that happened, but was essentially excused from the investigation afterwards. I don't know if they've made a identification of who exactly did it and if it was specifically Mr. Barber. But yeah, that's my argument, Judge. I'd ask for probable cause to not be found here.
All right, go ahead, Ms. Patton.
In addressing the venue, the officer himself said it was at Fulton County. I asked him again twice, was that Fulton County? He stated it was. For probable cause for robbery and the identification, the officer did testify to watching the camera footage, and that he was able to recognize the defendant from that video in which he saw not only the assault occur, but he was able to identify the defendant in it and pointed him out in court. I think there's enough to satisfy the probable cause requirement, which, as you know, is a lower requirement for robbery for this defendant, Mr. Darius Barber, and the state would ask that the court finds as such.
All right, I'll file probable cause on robbery. He's got $15,000 good bond, April the 5th. You want to address it again?
Yes, Judge.
Pre-trial.
This defendant has 11 arrest cycles in Georgia beginning in 2012. No felony convictions. There is an FTA of 2020 in 2021. Nothing further to report.
All right, go ahead, Mr. Rhodes.
Yes, Judge. Mr. Barber's 38 years old. He's from Georgia, currently living on Hollywood Road with his 5 children and a girlfriend of his. He made it through the 9th grade and probably could not finish due to a speech impediment and disability that he does have. He was working at the airport for 18 years and also was working at Popeyes for 3 years before arrest here. Still, Judge, as it stands, he and his family are not able to post bond. All I can ask for on behalf of Mr. Barber is a UJR, but I understand if the court's not inclined to give one, we'd ask for a $5,000 bond so that perhaps he can be referred to the bail project. But I would again note that, he had a pretrial surrender on another case, Judge, that's right now in no bond status. So even if bond is set on this case right now, until we address the other case, 23 CP 21570, I can't see the last number.
2.
But 2. Yeah, he'll still be held in jail on that case until that's addressed as well.
Okay. What says the state?
Your Honor, this defendant does have a bond as he is entitled to. We don't believe the bond should be lowered. However, if Your Honor is inclined to set a bond, I believe pretrial did mention an FTA on his pretrial report. If Your Honor is inclined to lower the bond, we ask it to be no less than $10,000 with an ankle monitor attached to this defendant, 24-hour curfew, exceptions of legal, medical, and childcare. I believe Mr. Rhodes said he does have children. And no weapons while out on bond.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 91 Peachtree Street. No further contact with David, last name Borgiet. Stay away from Woodruff Park, Georgia State University property, and 5 Points MARTA station. You'll have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, and basic life necessities, anything having to do with your children, $10,000 good bond. If you have a hold or anything, you'll have 48 hours to have that ankle monitor placed on your ankle if you're released from a hold. $10,000 good bond. Best of luck to you, sir. Now we got David Penix.
Penix. Well, I don't know, actually. I'm guessing.
Penix. All right, number 3, come on up. Here, come on.
I gave you a copy of the warrant.
That's what I need to,
Is it just one copy to it?
yeah, you just have me one copy of that.
Okay, I usually make two.
Do you need it? Do you
I may
your
have
own
to
copy?
exchange it back and forth.
I've got my report, so if you
Okay,
need this.
yeah, I would. Thank you. I usually make two, but every now and again. I make mistakes.
Very nice. You representing all of them. Okay.
I know.
So I
I don't know how that happened today.
There's a lot.
It's odd.
You got two more. after me.
Well, yeah, but none of the officers are here. Oh, this is the last.
So they're not here, then you can go.
I know I made two. I
they'll-
remember his
We'll see what
face.
happens. They'll either get dismissed or reset.
Ah, I have it. I know. I told you.
There's no reason for them to come out.
Yeah, I mean, it's a long one.
See, this is the-
And I highlighted.
Sorry.
Right, yeah. But also, yeah, it's serious mental health. issue.
Sit right here in this chair next to your attorney, please.
Oh, good, how are you?
All right. This is position 3. It's 23 CP 217448. David, is it Pinnix? Pinnix, Pinnix, 73 days without indictment, got burglary in the second degree, public drunk, 2 counts of misdemeanor, willful obstruction, and disorderly conduct. Right now, as of April the 4th, he has a $3,500 split bond with no bond on the robbery. Officer, if you raise your right hand,
It's a burglary charge.
burglary, sorry. Got the other one. You swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
I do, ma'am.
All right, you state your name, spell it for the court reporter?
My name is Major Massey, spelled Major Massee.
All right, go ahead.
Hi, Mr. Massey, what's your title? I want to make sure I get it correct.
I'm a sergeant. with
Sergeant,
the
okay,
Georgia Tech
Sergeant
Police
Massey.
Department. Yes, ma'am.
Okay. How are you today?
I'm fine, thank you.
Where are you currently employed?
Georgia Tech Police Department,
And how long have you been there?
approximately a year and a half.
Are you post-certified?
Yes, ma'am.
Okay. And were you employed at the Georgia State Police Department on or around April 3rd, 2023?
Yes, Georgia Tech Police Department, April.
Georgia Tech, excuse me,
That's all
Georgia
right.
Tech
That's
Police
okay.
Department. Okay. And were you post-certified at that time?
Yes, ma'am.
Okay. So how did you become aware of the defendant?
So at that date and time, again, April 3rd, approximately 19:15 hours, I was still on patrol. And so I was advised by employees and managers at one of our dining facilities that a subject who had been terminated had arrived on scene and was currently stealing items from the freezer. So I arrive on scene, speak to management, and they said, hey, this guy's already left. You missed him, probably been 4 minutes. And they gave us a physical description of him.
Okay. How do they physically describe him to you?
They say he was a light-skinned black male, black t-shirt, tan pants, white shoes, carrying a colorful tote.
Okay. And just to clarify, they said he had been working there.
At one point in time, he was an employee. but
Okay.
He was not an employee at that time. He had been terminated already.
So they knew who he was.
So they knew who he was.
Okay. Did they say when he was terminated?
I don't recall the date of termination.
Okay. So you come out there. Did you see anybody of that description there?
Not at the time, no.
Okay.
We rode around the area, and after I wasn't able to locate, I drove back to the scene to complete my report, speaking to management.
Okay. And then what?
And then when I arrived on scene again to complete the report, I was advised by one of the managers that another employee called them and said, hey, we see him. He's up at the varsity.
Okay. So you came back to finish your report.
That's correct.
And when you got there, a manager told you another employee called them and said, hey, he's at the varsity.
Yes.
Okay. Where in proximity is the varsity to that? I think you said it was a cafeteria.
Mhm. So the varsity is technically within our jurisdiction. It's within the 1,500-yard footage of Georgia Tech property.
Okay.
So it's very close on North Avenue.
Do you have the address for that cafeteria?
May I check my report?
Oh,
Take
sure.
the written down
You can't
acknowledgement?
read from it. Just,
Sure.
okay.
So 649 Techwood Drive Northwest is the Britton Dining Hall.
And is that in Fulton County?
Yes,
Okay. The varsity, is that in Fulton County?
yes.
Do you have the address for the varsity?
Let me reference my report.
Sure.
61 North Avenue Northwest.
Okay. After you were advised that the suspect was potentially at the varsity, then what?
So I arrived at the varsity, and Sergeant Strully, who's also with the Georgia Tech Police Department, got there about the same time that I did. And he said he saw what someone he believed was matching the description go inside of the varsity. He gave me a physical description. He said, you know, light skinned black male, black shirt, khakis, white shoes. He said blue underwear showing. Well, blue underwear showing had also been a description provided by the managers on scene. So that was an extra confirmation that the one inside the varsity was the subject we were looking for.
Okay. And who did you say advised you that the suspect had gone in? You mentioned a name. I just
His
didn't
name
get
is Sergeant Strully,
spell what you're.
Sergeant, obviously, and then Strully, Strully.
Okay. Sergeant Strully, is he with your police department?
Yes.
Okay. So once he witnessed the suspect, you said same clothes matching, went in, then what happened?
So we walk inside, and I see the subject. He's leaning on the counter inside the varsity. And so I go up, introduce myself, and tell him who I am, and ask him to come over and speak with me. He tells me that he's not going to do so. And I said, you know, you need to come speak with me. And I told him why. You know, here's the reason I'm here. You know, you had an interaction on Georgia Tech property, and we need to talk about it. He made an aggressive stance and told me to get the fuck up out his face. And so then, you know, I continued to say, sir, you need to come over here and talk to me. And he told me multiple other times, fuck you, not going to do it. So when he made the aggressive stance, I pulled my taser from my person and pointed it at him. And I told him multiple times, I said, look, here's the deal. I'm not going hands on with you. You need to talk to me. I've got my taser on you. I'm going to ask you to get on your knees for me. And I told him, gosh, 4, 5, 6, 7, 8 times, please get on your knees. Please don't make me do this. And he continued to tell me he absolutely was not going to do it. So I utilized my taser in his rear, and it was successful. It caused him intermuscular lockup. At that time, we then detained him. We placed him in the handcuffs. At one point, he continued to be combative in the cuffs, and we all fell to the ground. His face did strike the ground. We observed bleeding from his face. We immediately requested that ambulance be en route. He did not have an ID on his person at the time. So while we had him detained and while we were waiting on the ambulance, we used our mobile fingerprint scanner, which did return with positive returns with Mr. David Penix. Did advise that he had 2 warrants out for him as well. Grady arrived on scene, placed him on a stretcher, put him in the rear of the ambulance. He was transported to Grady Hospital, where he received medical treatment, and he was eventually cleared by Grady, and he was transported to Fulton County Jail, where he was booked.
Okay. All right. So let's go back. In the varsity, were there other patrons there?
Yes, there were.
Did they observe this interaction that you were having?
Yes, they were. There were other people at the counter.
Okay. And the counter, do you mean like the actual cashier counter or just another counter in the
One long
restaurant?
big counter where everybody orders, and there's cash registers as well.
Okay. You did say you advised the suspect as to why you needed to speak to him, correct?
Yes.
Did he indicate to you that he didn't know anything about that, or?
No, it was just immediately get the fuck up out my face.
Did he offer to do any violence?
Not with his words, no.
Not with his words.
When he told me to get the fuck about his face, he turned his body and made an aggressive gesture towards me.
What was that gesture, if you could just describe it?
More of a lunge, not an actual attempt to lunge. He didn't come towards me enough with a reach, but it was an aggressive demeanor of, hey, you know, it was very evident that he did not want me getting close to him or laying my hands on him.
Okay. You said he said to you, get the fuck out of my face. Did he say that to any other officer?
Specifically towards me.
Okay. When you arrived first at the, we're going to go back. When you arrived first at the cafeteria and you're talking about, what did they say had happened?
They said that he had arrived onto property and that he had gone into the freezer and had stolen food items.
Okay. How did they indicate to you that they knew that he had done that?
They saw him do it.
Okay. Did you speak to the person who actually saw him do it?
The manager that I spoke to, I believe, was a witness to it.
Okay.
Now, I have reviewed video footage that does capture him committing the act, And there is another employee out there, but I don't specifically know their name.
Okay. The video footage that you looked at, was it in color? Was it in black and white?
Yes, it was in color.
Was there audio?
No.
Okay. And in the video, are there timestamps on the video?
Yes.
Are the timestamps those that match with the initial report time? Are they around about the same time? Okay. And in the video, tell me what you see.
See him going into the pantry, or excuse me, the freezer, and I can see him coming out with items in his hand.
What type of items?
One of the items was a box that at one point he had dropped one of the items on his way out. Because when I arrived on scene, I noticed a big box of meatballs that was strewn in the way.
Mm-hmm.
But he comes out with items.
Okay. Did anyone ever indicate to you that he had permission to retrieve the meatballs or various food items?
No, they told him I was advised by the manager he had been told he needed to leave. He wasn't supposed to be there.
Did they indicate to you that he had said why he was coming to get those meatballs?
No.
Did they indicate to you that he was the owner of those various items?
He was not the owner.
Okay. Okay, let's move forward a little bit. After you watch the video and you watch him retrieve those items and come out of the freezer with multiple items in his hands, then what happens?
Well, then he takes a route up North Avenue.
Okay.
Which is where we at what later point in time find him inside of the bar seat.
How did he get to North Avenue? Do you know?
He walked.
Okay. Do you have?
Techwood Drive intersects with North Avenue.
Oh, okay. Do you have footage of him walking?
We have partial footage of him walking, yes.
Okay. And while he was walking, did he have the items in his hands?
At the time, he had a tote bag. Now, it should be noted that after arrest, upon search incident to arrest, we found frozen food items in his tote bag.
Okay. Were those the same items that had been taken from the?
They were corn dogs and French fries. Now, at the time, the manager did not have a list specifically of what exact items were taken. I just was told frozen food.
Did you ever get an itemized list of what had been taken?
I did not.
Okay. Is there anything of note about the incident of him taking items from the fridge that you saw in the footage?
In what aspect?
Did he just come in empty-handed and walk into a fridge and take items?
He just came onto the property and then went to the freezer, took the items and left. Now, he was extremely intoxicated at the time I encountered him.
How do you know he was intoxicated?
Slurring of his words.
Okay. Did you smell any alcohol on him?
I did not smell alcohol. I will say that, again, searching his items incident to arrest, we had found a bottle of, I believe it was brandy that had been consumed.
Brandy?
Brandy, I believe it was.
Okay.
And a 6-pack of beer with 3 beers left. Now, I was also advised by the officer that was transported went with him to Grady since he was in our custody.
Mhm.
He had been so very aggressive with Grady that they had eventually had to sedate him in order to get vitals. That officer told me he had been advised by Grady that he had tested with cocaine in his system.
Oh, okay. Did anyone, be it the EMTs or the other officers, state to you that they smelled alcohol on this defendant, or did you?
No, I did not smell alcohol.
Did anyone else advise you that they had smelled alcohol on this defendant?
No.
So we're going to skip forward here. You said he was tased at Varsity. Was he arrested at that time?
He was in our custody, yes.
Okay. Did you read him his Miranda warnings?
No.
Okay. Did you ask him any questions following him being in custody? Okay. And when you executed the arrest, what was his demeanor?
Very combative, very angry. Of course, we did, like I said, we utilized the taser, put handcuffs on him. At the time, he was still combative.
Okay. Would you recognize the individual you had the encounter with at the Varsity?
Yes.
Was the individual from the Varsity the same person who was on the footage that you saw with the incident of taking the stuff out of the refrigerator?
Yes.
Are they in the courtroom presently?
Yes.
And please feel free to stand if you need to. Please indicate whether they are on my left or on my right in an article of clothing.
Subjects on your right side, sitting at the table in a blue Fulton County inmate.
Okay. Please let the record reflect that the witness has identified the defendant, Mr. David Penix.
All right, record will reflect.
You've charged Mr. Penix with 2 counts of willful obstruction of law enforcement officers. Those are misdemeanors. What's the probable cause for those 2 charges?
For the misdemeanor obstruction,
Yes.
I had given, when I got there, I was wearing police uniform, easily identifiable as law enforcement, introduced myself, explained to him my lawful reason for needing to interact, refused to interact with me, gave him multiple lawful commands to get down on his knees and asked, and in fact, begged him to please not make me utilize my taser. I told him I did not want to do it, and he failed to comply.
Okay. You also charged him with disorderly conduct. What's the probable cause basis for that charge?
The cussing and aggressive behavior within a restaurant that was full of patrons.
Okay. And specifically yelling explicitives at you. And you said there were other patrons present.
Yes.
Were the other patrons, were you ever able to interview them?
No interview was conducted.
Okay. Were other patrons watching while this was happening? Did you overhear anyone make any exclamations or concern?
No.
Okay. You've also charged him with burglary in the 2nd degree. What's the probable cause basis for that cause?
He entered an unoccupied structure that belongs to Georgia Tech and was on our property.
Okay. You also charged him with public drunk, which is a misdemeanor. And what was the basis for that?
The slurring of his words, as well as the possession of empty alcohol containers.
Okay. The description that you got from the employees of the cafeteria, did they ever come to you later and identify specifically this defendant via like a photo lineup or anything like that?
Just a confirmation of the name. We had a David Penix in our custody, and they advised that the employee who showed up on scene was named David Penix.
Did you ever run a GCIC on Mr. Penix?
Yes, I did.
Did a picture come up with the GCIC?
I don't recall.
Okay. Did you ever see a driver's license picture of Mr. Penix?
I don't recall because, again, he didn't have an ID, so I had to utilize a mobile fingerprint scanner. But because his fingerprints are in the system from prior arrests, that was a confirmation of his identity.
Okay. Did they ever tell you that there was anyone else named David who worked there?
No.
I believe I already asked you this, but I'm going to ask you again for the sake of being clear. Are you post-certified?
Yes, I am.
Were you post-certified at that time?
Yes, I am. Yes,
Okay.
I was.
Nothing further at this time.
All right, Cross.
Good morning, Major Massey.
Good morning, sir.
Again, 649 Techwood Drive is the cafeteria location.
That's correct.
And it's alleged that the suspect, Mr. Penix, went inside a freezer there. Is that right?
Yes, sir.
Could you describe a little bit more what this freezer is like? Is it a walk-in freezer?
Yes, it is.
Okay. And that walk-in freezer, is it located again inside the building of 649 Techwood Drive?
It is on the property. It's right next to it.
All right. And I believe on the warrant you mentioned it was by the loading dock. Is that right?
Yes. Mm-hmm.
Okay. And this was around 7:15 p.m. Is that right? At what point, do you know who first alerted police about the incident?
One of the managers, if I recall correctly.
Did they alert as the incident was happening?
I cannot tell you exactly. No, I cannot tell you if they called as he was leaving or while he was there. I don't want to tell you wrong.
Did they mention interacting with or speaking with the suspect at the time while he was there?
I can't specifically tell you which one interacted with him. No. I could reference my report and see if it's mentioned specifically, or we can, if you want to move on, whatever you want to do.
I have time. Again, yeah. Did anyone at 649 Techwood speak with the suspect?
Yes.
They did?
Yes.
Okay. Okay. Do you know who that witness would have been?
I'd have to check my report and see if it was one of the managers or.
Okay. You can check your report if need be.
No, I don't believe I specifically mentioned which one interacted with him.
Okay. Still, you yourself spoke with one of these managers, right?
Yes, sir.
Were you able to get their name?
Yes.
What was their name again?
I'm going to reference my report.
Mm-hmm.
There is a Corey Charles and a Joseph Rush.
And both of them had a familiarity with the name of David Penix, right?
Yes.
And they both essentially point or accused David Penix of being the person entering the freezer that day.
At the time, they just gave me a physical description because he had been advised that he had left so close within my arrival time that I gathered a physical description and then began to search.
All right. Was there footage of the suspect leaving the freezer
Yes.
with boxes in his hand?
Yes.
How many boxes?
I believe two, but I don't want to tell you 100% and be wrong.
All right. And no one performed an inventory to find out what exactly was taken?
No, I asked managers on scene to please follow up with me because they could not tell me specifically about inventory. And so I asked them to please reach out to me once they had done so, and I never heard back.
Okay. Had you spoken with either of these managers about this incident after the arrest?
No, I'm not.
Okay. Now you mentioned that there was footage of the suspect walking afterwards. Could you see the suspect walking towards the varsity?
I could see him turning, well, not turning because he was on foot. I can see him walking onto North Avenue from William Street.
Okay. And walking onto North Avenue, I know the varsity is basically on North Avenue. Was he walking, well, yeah, turning towards where the varsity is or turning away from where the varsity is?
Towards.
Okay. Did anyone at the varsity alert police to a problem that was happening there?
No.
Okay. But it was just your investigation. Remind me again how you, ascertained that the suspect was located at the varsity?
An employee contacted one of the managers who filed the report with us and said he's at the varsity.
Okay. And he was lying on a counter?
Leaning.
Leaning. Okay. I misheard you the first time. All right. Now you mentioned that there was a Sergeant Stroley who was also at the varsity.
Yes.
Were there any other officers involved in this investigation?
There was another officer who arrived later when as we were interacting with the subject. But most of the predominant amount of interaction with the reporting party was me.
Okay. And you were the one who, gave commands to the subject, right?
Yes.
You eventually tased the suspect, and he fell to the ground afterwards. Is that right?
He did not initially fall to the ground because we immediately grabbed him and put handcuffs on him to prevent that. But because he was so physically combative, we ended up on the ground.
You mentioned that he had a bag on him. Is that right?
He had a tote. Yes.
A tote bag. Inside that tote bag were the two boxes.
No, it was
there?
It was food, frozen food.
Okay, frozen food that were not in like the cardboard boxes that you could see leaving
That's
the
right.
freezer. Okay. You mentioned that there was, some alcohol in there as well, right?
Yes.
Is there anything else inside that tote bag?
I just recall the food and empty alcohol bottles.
All right. To your knowledge, was Mr. Penix given a breathalyzer test?
No.
Any blood samples drawn?
If there were, they weren't at request of law enforcement. What they did at Grady, I can't tell you.
Yeah. All right. That might be it. Give me one small moment. And you mentioned again that you don't have knowledge of when Mr. Penix was terminated from the cafeteria,
That's correct.
but he did work there at some point.
That's correct.
All right. Thank you, officer.
Okay, thank you.
Anything else?
Major.
Anything else on direct?
Nope, not at this time, Your Honor. Thank you.
Anything else, Mr. Rhodes? Sorry, I think I
Yeah.
cut you off before. I was just used to, go ahead. Yeah, I don't know if you had to ask anything else.
No. If I can ask one more question.
Sure.
Did Mr. Penix sustain any injuries after the arrest?
Yes, he did.
Could you describe those injuries if you know them?
When we went to the ground, he sustained injury to the face because he was bleeding from his mouth.
All right. Were you able to get a look at Mr. Penix's teeth afterwards?
No, I did not.
I didn't hear you. I'm sorry.
No, I did not.
Okay. Thank you. Those are all my questions then.
Anything else?
I do have one, and my apologies. You did indicate to Mr. Rhodes that you didn't order any testing of blood or alcohol. Is that correct?
Yeah.
Are you aware of anyone else, any other law enforcement ordering that?
Not an order, not to my knowledge.
Okay, but you did indicate that there was cocaine in his system.
Yeah, so the other officer that was on scene,
Uh-huh.
they went to the hospital with him. He advised that he was informed by healthcare staff that there was cocaine in the subject system. So that officer would have to testify and tell you further. I can
Okay.
just tell you what our conversation was.
Okay. Nothing further. Thank you, Your Honor.
Any follow-up?
No, Judge.
Okay, thank you. Stay safe out there.
Yes, ma'am. Thank you.
All right, go ahead with argument.
Judge, I misheard. Time for argument?
Sure.
Okay.
But go ahead. I didn't know if you're still talking to him.
Oh, no, nothing for the witness. I'm ready for argument.
Okay.
In regards to count two, public drunkenness, we don't have any evidence per se that Mr. Penix was actually under the influence of alcohol or drunk in any way. Yes, the officer referred to slurred speech patterns that Mr. Penix may have had, but I mean, we were just talking about speech impediments before. People can sometimes have slurred speech. It's not directly attributable all the time to alcohol. There were no tests done. There was no smell of alcohol. I would imagine, as close as the officer eventually got to Mr. Penix during the whole arrest, if he were drunk and actively drunk, he might have actually smelled some alcohol, but we don't have that, Judge. I'd ask that there be no probable cause for that. Also, in regards to one count of willful obstruction of law enforcement, I don't believe that there was any evidence or testimony that Mr. Penix had obstructed at least a second officer. Yes, there is testimony, of course, that he refused the commands of this witness here, Major Massey, but there was no testimony about any obstruction beyond that. So I ask that there be no probable cause for that count as well. On the remainder of the chart, one moment, Judge. On the remainder of the chart as Judge, I will submit to or defer to the court on the decision.
Go ahead.
Yes, Your Honor. The officer did testify that a witness had told him that the defendant was drunk. That, in combination with the fact that on the defendant, I believe he said it was an empty bottle of brandy and 3 out of a 6-pack of beer was empty. I think that meets enough for the probable cause element on the misdemeanor of public drunk. For the willful obstruction of law enforcement, there's 2 charges because the witness testified that 1, the defendant would not comply and speak to him. 2, that the defendant cussed at him and named multiple incidences in where the defendant was repetitively being refusing to be arrested and being aggressive towards the officers. There is enough to satisfy the probable cause element of 2 willful obstructions of the misdemeanor, and as such, the state would ask that you find probable cause in every charge listed for this defendant.
So I'll find probable cause on the public drunk, because in the statute, it just says, shall appear to be intoxicated condition in any public place within the curtilage of any private residence, not his own, or by invitation of the owner or have lawful occupant. It doesn't really say by boisterous, indecent condition, or act by vulgar, profane, loud, unbecoming language, guilty of misdemeanor. It doesn't say necessarily like alcohol or drugs, but probably should be public intoxication. But I'll find probable cause on that. Burglary in the 2nd degree, disorderly conduct. Now, the misdemeanors, I'm going to find it on 1. And the reason I say that is because in one of them, it talks about Sergeant Strelly. I think I'm pronouncing it right. Sergeant Strelly. The other one talks about this sergeant. So I'll find probable cause on 1, and it's in the EW. Let's see. It's in the warrant ending in, let's see, it's EW 0398432. That's the one where it talks about Sergeant J. Strelly. So I'll find probable cause on one of the obstructions and the public drunk. So everything but one obstruction, I'll find probable cause in. He'll tell you just because it's dismissed now for no probable cause, they can still indict on that and you still have that charge come back up later. There's a $3,500 split bond with, like I said, no bond on the burglary.
This defendant has 29 arrest cycles in Georgia beginning in 2001, a felony conviction in 2003 for possession of controlled substance, probation violations in 2003, 2006, 2008, 2009, 2010, 2011, and 2020. Failure to appears in 2002, 2003, 2006, 2007, 2009, and 2022. Nothing further to report.
All right, go ahead, Mr. Rhodes.
Yes, Judge. Mr. Penix is 39 years old. Geez, I didn't write this down. Sorry about that, Judge. I just didn't have that exact detail ready, but he grew up here in Georgia. He was working, he has family here in Georgia. He was working at the CNN Center for 2 years and has received his GED. Judge, he has admittedly, by his own admission, a drug and alcohol issue that he has himself proactively tried to get admittance into a rehab program for. I have tried for today's purposes to have a letter of admission to one of these programs, was not able to get that yet. I'm hoping to be able to get a letter of admission soon, but he was, to my understanding, accepted into a Salvation Army rehab program. It would be a residential program, in-house treatment facility. He would just, of course, need to be released from jail to start that. Should the court inquire about an admittance letter, I'll still do my best to have that letter whenever I first get it. I'll
Is
say,
that program?
I'm sorry?
Is that program 6 months?
Yes, Judge.
Okay, I know one's a year, one's 6. I can't forget. Okay, I think so.
He does, as well have a DeKalb hold and a Clayton hold. I will say as well that, as a result of, this arrest, he did receive, permanent injuries to his teeth. One was knocked out and one has been, irreparably cracked. It might as well be taken out as well. They're 2 front teeth. He was looking into, going into the, visual entertainment industry as an actor, but now, of course, would not be able to do so that easily. Judge, he doesn't have any money to bond himself out at this moment. Considering he has these 2 holds already in DeKalb and Clayton County, and at this point, I guess a pending admittance into a rehab program, we would just ask again for a UJR to the holds if the court or the law allows. Beyond that, Judge, in the alternative, should DeKalb or Clayton not pick him up, we'd ask for a $5,000 bond in total.
It looks like one's a misdemeanor probation, the other one's a CWAC probation, I think. Okay.
What county is the CWAC probation in?
Cab. Like it's a probation warrant, yeah, for out of the cab. Clayton is a misdemeanor of, hold on. Okay, misdemeanor obstruction. Yeah. So I don't know if the cab will, but I'm pretty sure Clayton will come in. Go ahead.
Your Honor, the state would defer to Your Honor's discretion on whether or not to set a bond in this case. We just would like the court to take notice that this defendant does have 29 cycles, multiple probation violations, and multiple FTAs. As such, that would serve as a likelihood of fleeing and a significant likelihood to reoffend. But again, state would defer to the court's discretion. I know he's coming up on 90 days here. So I think you have a way of setting a bond once 90 days starts. So I'll just defer to the court's discretion on the amount and the conditions.
All right, so he's got bond on everything but the burglary. So I'll do no drugs unless prescribed, no alcohol, no weapons. Stay away from all Georgia Tech property. Stay away from 649 Techwood Drive. Also stay away from 61 North Avenue. That's the varsity. You have an ankle monitor paid for by the county, a 24-hour curfew, court, lawyer, medical, employment. You have children?
Yes.
Yeah.
Okay, childcare, basic life necessities. Okay, then you can leave. And I say 24 hours because so if you work a night shift, then it'll cover the night shift. That's why I kind of make it that. So it depends on whatever. You have to have the ankle monitoring company know what shift or when you work. And also Mr. Nelson, you have 48 hours to have that placed on your ankle once you're released from Clayton and or DeKalb or both. And if you get accepted in that program, let us know. I don't know who's going to be on at night anymore, but I guess you could email Mr. Malkin
That would be your best bet.
Sure.
and include me on that. And I'll respond that, yeah, we talked about it in court if he gets into that program. So we'll do 4,000 on the burglary in the second degree, UJR for the public drunk, 1,000 on the obstruction, and UJR on disorderly conduct. So 4,000 UJR, 1,000, and then UJR.
All right.
Best of luck to you, sir.
Thank you, Your Honor.
Okay.
And again, to clarify, as I had asked before, it's not a UGR alternative, bond. It's just the straight 4,000.
What's your,
UGR to the hold.
Yeah, UGR to the whole.
you want?
Is that what you meant?
Yeah.
Yes.
Yeah, that's.
So, okay, we'll do that. Same thing, Ms. Hunter, do that or UJR to the whole. I don't know if Clayton will come, but the cab probably will. So it's that 5,000 or UJR to that hold. You got that, Ms. Hunter, or did I lose you?
I got it.
Thank you, Ms. Hunter. Thank you all. Stay safe. Now you have made me want varsity talking about.
Yeah.
No,
I
you can
think I
bring,
might have an issue if I go to the varsity.
you
For the
can
whole
bring
rest
out
of the
either one.
calendar. You wanna sign
Robert Wright
something?
or Carlos Jackson, whichever
Okay.
one you want.
Sergeant Massey, do you mind writing your number? It's so difficult sometimes to find you guys.
Either
I would
one.
like to add it to
Wright
the-
or Jackson, it's the last two.
So you understand that now the case is gonna proceed.
Yeah.
That is- We're gonna indict it anyway, so.
Okay.
Thank you, sir.
Just got the next item.
Yeah, Wright and Jackson are the only ones, so whichever you want to bring out. So either one of them have. I don't know if either of them have a.
Okay. Did good though, that, well, obviously you're a sergeant, so you know, because this warrant was detailed. Pretty easy to go through.
Let's see, Wright has 15,000. Let me see, Jackson have a bond?
Agency number.
Okay.
Odyssey is not cooperating with me today.
Alrighty, so,
Anything else that you need from me?
no, so once this is indicted,
Jackson has no bond.
then,
It's like,
they'll see if they're gonna do a trial or work it out or whatever. It's gonna be indicted off, so,
Okay. All right.
yeah. Got probable cause. Thank you for coming out. Is this your day off?
No.
Oh, well, good.
I now have a regular Monday through Friday gig, so.
Whoa.
Step over here for me, sir.
Yeah, it's a big deal. Congratulations. Yeah, thank you. Thank you for coming out.
all right, you're Robert Wright? Okay, let's see, it's 23, it's number 6, 23 CP 217456. Robert Wright, 73 days without indictment. He has a $15,000 good bond. It's receipt, possession, transport of a firearm by a convicted felon or felony first offender. Ms. Patton?
Yes, Your Honor, the state would request a reset. I do believe the subpoenas were sent out, so we would just be requesting a one-time reset. It's for Hateville officer. I cannot pronounce his last name, so I'm not gonna try. I don't want to butcher it.
All right, go ahead, Mr. Rhodes.
Yes, Judge, we'd ask for this case to be dismissed for want of prosecution. The officer has apparently, yes, been subpoenaed. It's his duty to appear for that subpoena, and we have no, legally binding excuse for that officer to have not appeared. Per the calendar, all parties are required to show up at 9 a.m. There is no officer here. We, again, just ask for the case to be dismissed for want of prosecution.
And it looks like pre-trial, does he have holds, 2 holds?
Yes, ma'am.
He
Okay,
does, yes.
thank you,
Sir, I'm
pre-trial.
sorry, I couldn't get my Odyssey's acting up as well.
Okay, that's all right.
What are his holds in?
Yeah, Cobb and Floyd.
Yes, ma'am.
Yeah, Ms. Hardy, some of your paycheck needs to go to Mr. Wright for helping you out here today. All right,
Oh,
so
sure.
I'll give the one-time reset. You want that same date that we had before if it's still open? Ms. Watts was it the 29th?
Yes, Judge, at 9 a.m.
Can I hear his pretrial report?
Oh, we will, but I'm gonna reset till June 29th. 9 a.m. All right, go ahead, Ms. Hardy.
Is there another chance to show up? So,
You're on mute.
hold on,
Is this position number 6?
Yes, ma'am.
Okay, this defendant has 20 arrest cycles in Georgia beginning in 2007. Felony conviction in 2013 for aggravated stalking terroristic threats. 2018 for aggravated stalking. Probation violations in 2008, 2013, 2015, 2016, 2017, and 2019. Nothing further to report.
All right, go ahead, Mr. Rhodes.
Yes, Judge. Mr. Wright is 32 years old. He does have a mailing address here in Georgia. However, he plans to actually move to Florida should he be released. And we do have an address for that as well. He'd be living with his uncle. Either way, Judge, he does have essentially 2 mailing addresses. One here in Georgia with his aunt and one in Florida with his uncle. He's not at risk to flee the jurisdiction. He is as well a Georgia native. He's from Georgia and had been working at a family-owned security company. The court may have concerns about security companies and this specific charge that he has, but as part of his work, he is not carrying firearms. He has told me that he mainly does security detail for events that involve minors. So really, no firearms should be accessible really at that time anyway. He has a high school education as well, Judge, and has also been accepted. This time I do have an acceptance letter for We Are Living Proof. It is a residential 6-month recovery program. We have that letter. I can forward it to the court if needed. I just need to actually make a copy if needed. Judge, he does, as you've heard, have 2 holds, one out of Cobb, one out of Floyd counties. We would be asking for a UJR to those holds. And if neither of those counties pick him up, we would ask for a $5,000 bond.
Ms. Patton. $15,000 right now.
It's 50 now,
15, 1 5.
15.
Yes, ma'am.
Your Honor, he has a bond and it's fair and reasonable considering his history. He also apparently has 2 open cases. We would ask that you not lower the bond. If you are inclined to, I would ask that if you are inclined to lower there being condition of the if he makes the bond, he can only go to that program you said he's been accepted into?
Yes, We Are Living Proof.
What's the program?
We Are Living Proof.
Yeah.
Okay. Do they monitor them?
Yes. There are classes involved. It's a residential program. They are monitored. It's a sober living house, essentially.
Okay.
I have my probation there too.
What do you mean?
Your Honor,
Yes.
my probation officer, I talked to the lady, Miss Michelle. She said if I have probation there, my probation can come and supervise, come and give them the address where I stay at.
Yes, sir.
They'll come and visit me there while I'm at that program.
Oh, okay. So they'll come to you to report.
Yes, ma'am, I'll be making $18 an hour while working now.
Okay.
So that's why it's hard for me to make a bond because my fiance, she just got in a car wreck. My grandma just got in the hospital. So that's why all the people I depend on. And that's why I just ask you have mercy on me and give me another chance. I'm not a bad person. I do security for teenagers. So I don't carry a firearm at all.
Okay. Go ahead, Mr. Rowe. Go ahead, Ms. Patton. Sorry.
I was done with bond argument. It was to leave it the same. And if Your Honor is inclined to lower it, that you add that he can only be released to that specific program.
It's after the holes. I don't even know how to word that. Yeah, I don't even know how to I could do a bond. He can be released, and then part of his condition is he join that program
That could work.
as soon as he gets released from whatever there is in Rome or whatever. That way there won't be a date. So I'll do no drugs unless prescribed, no alcohol, no weapons. I don't want to like violate him though if something happens and he can't. So do you mean make it a condition that he join that program, or I don't?
I mean, he
I
wants,
don't, that's one where they have to have bed space. So if he gets out of Rome and they don't have bed space, then he can't get into it,
Oh.
right?
sure, but I think they
Yes,
are
they do.
reserving a
I have-
bed.
I have 3 roommates. The program is based off, you go to job and help you like recover from like you being an addict, you have mental problems.
Yes.
And it help you help yourself up. They
Right.
have a room and board.
Sure.
So it'd be me and 3 other roommates together. We can have our family, we can go home, visit our family for after our 60 days, we would come back on Sunday, have our classes. We have classes at nighttime.
Yeah.
And we got a curfew at 10 o'clock. It's strict, they drug test, and they no weapons is allowed up there, no smoking, no nothing.
Yes, Judge, and this letter is dated June 6, where they refer to Mr. Wright as a resident. So I'd imagine or hope that there's still bed space.
Okay, so what we'll do, since you got the others, we'll put an ankle monitor on there because I'm gonna require you to go and participate in that program, okay? With the court, lawyer, medical, participating in the We Are Living Proof program. And I understand if you have to go report to, just let the ankle monitoring company know what you need to know for a job, basic life necessities, and participation in that program, all right? And then you'll have 48 hours to have that placed on. Once you get relief from your holds, I'll make it a $3,000 good bond, okay?
Okay.
All right, best of luck to you.
$3,000 bond.
All right,
Judge, can you repeat the name of the program again?
We Are Living Proof.
We Are Living Proof. Okay,
Yes,
thank
ma'am.
you.
Yes, ma'am. And now, are you going to be on tonight, Miss Hunter? No, it's going to be Miss Jamie, sorry.
Yeah.
All right. All right, we can bring out Carlos Jackson. That's the last one.
I haven't heard of that program.
Yeah, Miss Hardy, is it going to be you tonight? I know Bostic is out.
I'm not sure who they have scheduled for tonight.
So if I email you the rotation, can you send it to whichever?
Yeah, I can get it to who needs to have it.
Okay, there you go. I just emailed you the rotation for tonight.
Okay.
All right. Now, Carlos Jackson.
Mr. Rhodes, can I just take a look at the letter? I just haven't heard of them. You know me from DeKalb, you know I'm a program gal. So it's for sober living.
Yeah.
So he's already made it past everything.
I just don't want it to not be a bed space and then him, because
Yeah.
it'd be a violent, so.
Well, hopefully he does well. What gave me pause honestly was the aggravated stalking and the stalking charge.
Well, and they'll go up there, so yeah,
Yeah.
they'll handle it, and
They gave me pause.
I get that.
that's what I figured. I don't know what they're gonna do with that probation, if they revoke it or. Who's the DA up there now? Is it Lee something? Been the same DA for a long time, I think, a lady, isn't it?
Is that near Brunswick?
Oh, no, Rome is north, like
Oh,
Cartersville.
you know what? I thought you said Bibb County, which
Oh.
would be Macon, actually. That's not even Brunswick. Floyd County's Brunswick.
Yeah, Floyd.
Over here
Yeah.
right from me. See beside the attorney, please.
All right, let's see. All right, this is position 7. It's 23 CP 217458 Carlos Jackson. 73 days without indictment, theft by shoplifting felony and theft by deception misdemeanor, and he is in no bond status. Go ahead, Ms. Patton.
Yes, Your Honor. The state would be asking for a one-time reset I don't believe this has been on the calendar before. I do believe this officer was properly subpoenaed. However, I've not heard from him, but I've, done the proper notification. So we would ask for a reset so that I could try to locate him to see what's going on.
Mr. Rhodes?
Similar announcement, Judge. No call, no show. Officers required to be here at 9 a.m. We don't know where that officer is. The state has no case to present. So we would ask for the case to be dismissed for want of prosecution.
All right, we'll do that one-time reset. We still have June 29th, Ms. Watts?
It'll be June 30th at 1 p.m.
June 30th. Is that good, Mr.?
Yes, Judge.
1 p.m. Okay, June 30th at 1 p.m. And on all those resets, when the officer didn't show, Madam Clerk, can you put one-time reset for officer to appear?
Yeah.
Thank you, because I just saw one of them didn't, but I can't add it to it. So can you add that to it if it was officer didn't show up? All right, we'll go ahead. He's in no bond status as of for April the 5th.
This defendant is a multi-state offender with offenses in Georgia and Alabama. Felony convictions, 2010 theft by taking, 2012 criminal attempt to commit a felony, 2013 theft by shoplifting, 2017 possession of the tools for commission of a crime, 2018 theft by shoplifting, probation violations in 2017 and 2018. In 2019, there is a parole violation. Nothing further to report.
All right, go ahead, Mr. Rhodes.
Yes, Judge. Mr. Jackson is 40 years old. He is originally from Alabama, yes, which may explain some of those cycles, but he's been living in Georgia for the past 13 years with his wife at the address on file in Lawrenceville. He, of course, also has a Gwinnett hold as well. I believe that hold is also related to a theft charge, Judge. He would have no problem, of course, with a stay away from the location and really a general stay away from Fulton County. This particular Home Depot, that is mentioned in the warrant is on the edge of Alpharetta, close-ish to Gwinnett anyway. So he'd have no problem with a stay away from Fulton. Judge, he's been in jail now 73 days with no bond. We don't know what's going on with Home Depot, or if they want to pursue charges at this stage. We would ask for a UJR to the Gwinnett hold. In the alternative, if Gwinnett does not pick him up, we'd ask for bond not to exceed $10,000.
Go ahead, Ms. Patton.
Excuse me. Excuse me, I'll consent to both. The UJR to the hold and a bond for the 10,000, the breakdown to be set by the court.
All right. So it'll be 5 on each. Ms. Hunter will be 5 on each, or UJR to the hold. No drugs unless prescribed, no alcohol, no weapons. Stay away from all Home Depot stores. Stay away from 5300 Windward Parkway in Alpharetta, Georgia. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, basic life necessities. As far as employment, you need to have proof of employment, name of employer, schedule, and the exact location you will be working. Also, stay out of Fulton County unless you're here for court or to see your lawyer. Don't come back to Fulton County for anything, sir. So it'll be 5 on each count, and then UJR to the hold. You're going to have 48 hours to have that ankle monitor placed on your ankle. Best of luck to you, sir. I think that's it.
Till 1.